Mediation specifically is a private, confidential meeting where you have this independent, neutral third party called a mediator who tries to not decide a case, but simply tries to say, look, one of you is over here, the other one of you is over here. Let's try to get together. Let's try to move this closer so that you can come to some resolution. And that resolution is going to be helpful so that you all can reach finality.
I'm Luke Carlson, and for almost 2 decades, my law firm, Ellis Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of Ellis Carlson Law. Welcome back to the show. Today I have Marty, the producer.
Hey, good morning.
Good morning. And a very special guest, Jeff Kominsky, live from Florida. Welcome, Jeff.
Thank you. Thanks again for letting me be here and talk to you about some hopefully pretty informative issues that people can appreciate and make informed decision at the end of the day.
Well, I love the topic. Before we jump in, though, I have to give you kudos because to date, you are the number one podcast that we've had in terms of views.
That is true. That is true.
So you are the high water mark.
Thank you very much. And, look, it feels good to have people watch, notice, and make great comments. And, why not do it one more time to help the people?
Yeah, so no pressure on this one.
All good. Here to help.
All right, Jeff. Wonderful. So let's jump right in. And, let me just start with the overarching topic, what you came up with. And I think it's absolutely wonderful. It's this distinction between the concept of mediation and arbitration.
Yeah, and I think when it comes to association disputes in Florida, for sure, you got to know that a lot of people get really frustrated with their associations, and they say, "What can I do? Why can't I just sue my association? Why can't they just do the right thing, get them off my back, and just go at them?" And that's where the law is pretty helpful in the sense that there are good laws in Florida that kind of give property owners opportunities to try to resolve their disputes without legal escalation and filing a lawsuit. And we're going to hopefully get into that a little bit. I think it's very important, especially because there are a lot of people out there that when they just want to sue, I have to say, hey, look, have you played the game Monopoly? And most people say, well, yeah, I've played Monopoly. Well, this kind of law relates to you can't collect $200 before you pass go in Florida, and there are certain things that you have to know before you pass go and file a lawsuit.
Right. The knee-jerk reaction typically is, I have a bad HOA. Let's take him to court. Let's run to court. But it's not necessarily how the law works in Florida. And let's talk then about that first step, which is typically mediation, if you want to jump into that concept.
Yeah, this is really interesting because as the only non-lawyer in this trio currently, I had no idea what the difference between mediation and arbitration and all of these areas are. So, and still to this day, even being around here for quite some time,
Right.
This is still an area of haze. So I'm excited that Jeff gets to unpack this a bit and I guess unpack on what the options are here,
Well,
particularly in Florida.
You're in good company because I can't tell you how many people we've consulted with in California who really don't know the difference either. So to give clarity to it, I think it initially empowers the homeowner to really understand, okay, these are the options and this is what those options really mean mechanically. So they really have an understanding of that tool. And it's a very powerful tool when used correctly. So Jeff, why don't you start with mediation? Why don't we just give a lay of the land? What is mediation?
Well, to just start, there's three words that end in TION that I think we got to talk about today. Mediations, for sure. I think the first one we want to talk about, arbitration, and then litigation. Just to throw litigation to the side, that's when you file the lawsuit. It's public record, public consumption, so everybody can see it. And that's the step that I believe you have to do only through trying to after you try to resolve your disputes. So mediation and arbitration. When it comes to mediation, mediation and arbitration are similar in the respect that you have a neutral third party to oversee your dispute. So keep in mind, it's not a judge. It's not somebody who was voted in on by, the public. Okay. Another thing about mediation and arbitration, it's trying to resolve it in a financially efficient way. But that's kind of where the similarities end. When it comes to mediation, mediation specifically is a private, confidential meeting where you have this independent, neutral third party called a mediator who tries to not decide a case, but simply tries to say, look, one of you is over here, the other one of you is over here. Let's try to get together. Let's try to move this closer so that you can come to some resolution. And that resolution is going to be helpful so that you all can reach finality and move on with your lives. And in association disputes, that's so important because this isn't typically like a personal injury case where you slipped and fell somewhere random and God forbid you injured yourself and you're just getting money. Well, in these types of situations, you try to resolve it because you're going to ultimately continue to have to work with your association. You're going to continue most likely to live there. So usually mediation is very helpful in trying to make sure that there's this, kind of kumbaya moment at the end that ultimately results in resolution and hopefully result in a signed, executed settlement agreement by both parties.
Well said. Also, when it comes to mediation, I like to focus on this notion of control and the controlling of the outcome versus, an arbitration and versus, let's say, litigation. So maybe speak a little bit to this notion of control and finality.
So if you try to seek mediation, or maybe an association tries to offer mediation to you, the person who is trying to institute or start the mediation does have a lot of control. And the control comes with trying to bring the dispute forward, trying to offer and propose mediators, which I can get into. And these mediators are very helpful, but a lot of them are experienced in association disputes, but some of them have very specific specialties, like financial related issues or contractual related issues. And so there's also a lot of control, more importantly, when you're in the actual mediation. You are the decision maker. If you make a demand and the other side counters and makes a new offer or a counter offer, then you have the control to either accept that counter offer, reject it completely, or perhaps make a new demand. And you have that control. Think of it like tennis. You're serving up the tennis ball or the demand. The other side has to figure out how it wants to swing back, whether agree to your demands, reject them outright, or swing in a different way or make you move. And that's when the metaphorical tennis ball or the counteroffer comes back to you. So the hope is you each can have control over your respective swings, and ultimately nobody wins a point. Instead, everybody either loses or everybody wins.
Who hires the mediator? Who determines who the neutral is, and who is a mediator? Are they typically a judge? Are they another attorney? Who makes up the composition of a mediator?
Yeah, I think I like that question because, okay, we sort of understand the concept of mediation, but maybe, Jeff, if you could walk us through in Florida, how does the mediation process, what triggers it? How does a homeowner or an owner sort of force, compel, or influence the other side to agree to the mediation? And what does that process look like from the point where you say, yes, I'm hiring a lawyer to go through the mediation process, to sitting down with a mediator? What is mechanically, what does that look like?
So mechanically speaking, it's a really great question, and this is where it can get a little complicated. So the good news is I'll try to kind of make sure everybody can understand it in a way that makes sense. So when we're talking about trying to start a mediation, if you're the one who has the legal dispute, you have to make sure that you have an appropriate legal dispute to use a right to offer mediation. And some of those legal disputes are based on what Florida law requires. For example, if you live in an HOA in Florida and you feel like you have not been getting access to records that you've tried to request, called official records, then any dispute regarding official records is equivalent to a legal dispute as defined in the statutes to try to ask the association, the HOA, to agree to a mediation. There are other types of disputes that trigger the relevant statutes, but you got to first know that there are certain disputes that trigger this right to offer pre-litigation mediation, and there's some that do not. Assuming you have a legal dispute that does trigger mediation, you do have certain rights, whether you live in a condo or an HOA, to use those rights. And if anybody wants to Google that, these statutes on their own time, for a condo, it is 718 of the Florida statutes, 718.111, or sorry, 718.1255. I apologize,
Hmm.
718.1255. And then for an HOA, it is Florida Statute 720.311. Once again, 720.311. Those are the two statutes that you're going to need to know, depending on whether you live in a condo or an HOA, to try to use this statute. Now, how do you use the statute? These two statutes, depending on where you live and what type of community, give you specific ground rules of how to bring your legal dispute and how to make your demands. The triggering point of the statute comes where you have to offer certain mediators or certain people who are knowledgeable, not necessarily judges, but people who kind of know how the law works, can understand certain situations, and more importantly, try to hopefully resolve both money related disputes and non money related disputes. So they're people who are just experienced. They don't have to necessarily be lawyers in Florida, but they do need to be approved by the Supreme Court of Florida. And
So
you have to
they have to be licensed. In other words, do they have to be licensed through the state of
they
Florida in
they
order
have to
to?
be they have to be approved through certification.
Okay,
And so
understood.
the way it works is whether you live in a COA or an HOA, you offer 5 mediator options, and there are certain things you need to include about these mediators. And then whoever receives this letter, has the opportunity to either agree to your demands or agree to a mediation. And if they agree to a mediation, they have to select at least one of the 5 mediators. But Jeff, what if they select more than one? What if they select 4 of the 5? What do you do? Well, in that situation, once again, it now comes to you. And you say, well, they've circled 4 of the 5 mediators. So of those 4 that they circled, I can choose whichever one I want to have as the mediator. And the law basically says that if they agree to a mediation with a mediator, there are 2 ground rules. The first general ground rule is that the mediation would need to occur within 90 days, 90 days of the date of the demand letter. And then the second ground rule is that if the other side agrees to a mediation, they generally also have to agree to pay 1/2 of the mediator costs.
Hmm.
And this is an important part of the law because Florida wanted to make sure that both sides kind of attended in good faith, maybe put some skin in the game, so to speak.
Sure.
And this is one of those things where they guarantee that these mediations happen sooner or later, and that hopefully most everybody attends the mediations in good faith.
So there's a bit of a fast track mechanism built in. So I guess the question I would imagine a lot of viewers would have is you go through those steps, you send the demand for mediation, and it's ignored by the association. A lot of bad associations out there, they just ignore it entirely. What is the legal consequence of that? And then maybe equally important is, what is the next step for the owner?
Can we wind that back take it back one quick step too? Because I want to make sure I understand Jeff's point again as the layperson here. So you have a dispute.
Okay.
You hire a firm.
Okay.
And Jeff would say, well, under the law for this particular dispute type, we are compelled to go through the mediation process first. Did I understand that right, Jeff? Depending on the dispute based on what the law says.
Right. So that's where monopoly comes into play, where if it's a certain legal dispute, the association would have 20 days from the date of the letter that is sent out to agree to one of three things. But yes, it is usually a precondition, or you can't collect $200 before you can pass go to ultimately file a lawsuit. And this is usually it's called a condition precedent. But basically that means is that the Florida court system didn't want overflooding of association disputes. And so that's why they've instituted certain legal disputes to try to get mediated or arbitrated first prior to filing a lawsuit or litigation.
And I might be jumping slightly ahead, but do some of those disputes require arbitration versus mediation? And we'll get to what arbitration is, but just on that topic real quick, do some disputes specifically state that this dispute goes to mediation, this dispute must go to arbitration, and this dispute you can do whatever you want with it?
Yeah, so it's kind of like the Three Little Pigs, if you will, right? So in terms of there's certain disputes that are in the relevant statutes that do trigger the statute as a legal dispute. There are two very specific disputes that don't trigger mediation. In fact, the law specifically says that any disputes involving an election or any disputes involving a recall, or basically a process to get a board member removed from an association board, those two disputes in and of themselves are not subject to immediate mediation. Instead, those two are required to go through this arbitration process or a secondary process. But ultimately, to just kind of put a bow on mediation and to kind of answer Luke's question, this is where I would tell you, and the question was, Luke, correct me if I'm wrong, was, when the other side gets a demand letter for mediation or an offer for mediation, what are the options? Was that your question earlier?
Well, more specifically, again, a lot of owners listening to the show are dealing with a bad HOA. It's the title of the podcast. So when you send a demand for mediation in good faith to an association or to their council, and that demand is ignored, what is the consequence of that? What does the owner do next? Because I think a lot of listeners may be saying, well, my board is unreasonable. I've dealt with a living nightmare for a significant amount of time. I have no faith nor confidence that this association is going to play ball with me. So even if we send the demand for mediation, either they're going to reject it or ignore it. Again, more bad faith coming down the pipeline. So I'm wondering, in that circumstance, what's the situation?
It's a great question, and I get asked it all the time. This is where I would tell you that I like to turn the law into a game show. Okay. Because when this letter gets sent out, and most likely a property owner sends a letter explaining that they have a legal dispute with their association, with their bad HOA, the association has an option, and they basically are in a game show. We've got door number 1, door number 2, and door number 3. Okay. Door number 1, within 20 days of the date of the letter, they agree to the demands in the demand letter. Door number 2, instead of agreeing to the demands, they agree to this mediation process. And then door number 3 is what you're asking. Door number 3 is they agree to nothing. They basically dare you to file a lawsuit. If you have a certain legal dispute under the relevant statute, And if they HOA says, you know what, I don't really care about talking to you about this, go ahead, file your lawsuit, go forward with litigation. There are legal consequences. And usually the legal consequence is resulting badly for the HOA. Specifically, what happens is, according to the law, that if they choose door number 3 and the property owner filed the lawsuit and the HOA wins in that property owner's lawsuit, then by statute, the HOA is not entitled to their legal, reasonable, winning attorney fees, or what are called prevailing party fees, because the statutes are pretty explicit that their failure to participate in the mediation process before a lawsuit waives their rights to any of these prevailing party fees. And the logic is this could have all been avoided if they simply tried to talk it out with you in the first place. And
Understood.
so that is usually why most associations take this, game show very seriously. And the thought and hope is that they pick wisely so that they can resolve their disputes sooner than later with the property owner.
Understood. Thank you for that.
Yeah, that's
Because I think
interesting.
it's important. So at this point, it seems like a good pivot point to arbitration. Sort of understanding the mediation process, what it entails, what are the potential outcomes of the mediation. Assuming, I guess, one of two things happen: the mediation occurs and it doesn't resolve itself, or the association takes door number 3. Is then the next step? I suppose then it's either the contemplation of an arbitration or litigation at that point. Then you're really ratcheting up.
Yeah, and a lot of it depends on certain situations. There's not one process, and everybody can, in certain disputes, trigger certain ways to consider mediation or arbitration. But just know that the thought is, hey, let's immediately go to mediation. Sometimes that's not the case.
Okay.
Sometimes the thought is, let's go to arbitration. To explain what arbitration is, I think we have to make sure we know the difference between mediation and arbitration, because mediation is all about this kumbaya moment, trying to resolve their differences so that it's not adversarial and ultimately they can be a mutuality or an agreement.
Mm.
Arbitration is a little different. Arbitration is an out of court process, but it is adversarial. There is a winner and a loser. Okay. And it is essentially thinking of it as like a private court, if you will. The private court, though, in Florida, at least, is regulated by the Florida Department of Business and Professional Regulation. It's actually a public entity. It's otherwise known as the DBPR. And the DBPR oversees association disputes. And so association disputes that are once again are legal disputes, depending on what the law says, might be subject to arbitration. And in a arbitration process, there is a back and forth, and then the arbitrator usually does decide the winner or a loser. What makes this process very unique is there are certain disputes that require mandatory or binding arbitration, like an election dispute or a recall dispute. And there are some arbitration disputes that are not binding. So part of the issue is if you go a route where you want to proceed with arbitration, or perhaps that's what the law requires, then you've got to know that certain disputes are non-binding. Well, what does non-binding mean? Non-binding basically means let's say you go through this arbitration process that can take a long period of time. It can take months, usually about 6 to 9 months. Could be less, could be more. But if it's a non-binding arbitration setting and the arbitrator rules, let's say, every way in your favor, well, great. You had a great day. That's wonderful. But the problem is that the non-binding setting of an arbitration allows the losing side 20 days to appeal. And how are they allowed to appeal? They're allowed to appeal in the county, in the public court system, in a lawsuit. So what you thought was a win going through a very long process could basically move you back to the beginning all over again. Kind of think of the game Chutes and Ladders. You think you're all the way to the top, and then you land on that ladder that brings you all the way down.
Jeff, out of curiosity, in Florida, so let's say you go through the non-binding arbitration process, you prevail, and within the 20-day period, a lawsuit is filed, I'm assuming state court. Is the win that you had in arbitration, how does that impact, if at all, the new lawsuit filed in the state court?
That's a great question. I was wondering the same thing, if that's entered into the court system, the process of arbitration, who won.
Yeah, I'm curious. I'm curious how it's factored in, if at all. Or also, I guess another way of looking at it is having that win, even though it's non-binding, maybe becomes a very powerful tool in negotiations with the other side. Because even though you don't have a formalized win, you might be able to leverage that in a negotiation, pointing to that as a huge victory that is likely going to happen again or repeat itself. So I guess it's two questions, Jeff.
Yeah, so to briefly answer that, what happens when in that situation where there is this 20-day period to appeal from a non-binding arbitration decision, if the losing side wants to appeal, they have to file usually in state court a complaint, what's called a complaint de novo. Okay. And ultimately, this does mean that you're not just putting aside the final order, but you're ultimately asking the judge to rehear a lot of the argumentation. So when you go down the ladder all the way, you don't start necessarily at go or start, but the other side does have a little bit of an advantage right out of the gate. But you do have to go through the same type of litigation process, which can be very long, very extensive, very time consuming and emotionally draining, and no guarantee that the case will win or not, even if you appealed it. So just know that when it does come to a trial or complaint de novo, the winning side in the arbitration does get a head start, but by no means does it mean that you're in the driver's seat.
Jeff, let me ask you this though. It seems like, you've gone through the arbitration process. You win. The homeowner wins, like hands down, gets everything they want out of it. And the other side says, well, we're going to decide to drag this thing on longer, and we're going to pay a bunch of money, and this is going to be a nightmare for us. It just doesn't seem like they'd be very compelled to go down the path of a lawsuit at that point. How many, in the scenario that you paint, is it frequent that the other side decides to push into a lawsuit? Because it seems like the destination almost seems predestined, if you get what I'm saying. So how many actually result in a non-binding arbitration? How many people that actually win? How many times does the other side actually say, okay, I'm gonna push this thing further? Or is that just a negotiation tactic in most cases to settle?
I don't know the exact metrics or data on that, but I can tell you this, that there are a lot of inflection points in trying to resolve. Once again, the whole premise of an arbitration is trying to resolve it without very extensive litigation.
Yeah.
And so one of the thoughts is you go through this process that takes months, and the arbitrator does sift through the information, the exhibits, perhaps testimony, and makes an informed decision. Okay, in his or her best infinite wisdom. Ultimately, if it's a non-binding decision, yeah, you can use that if you are the winning side as an immediate inflection point to try to resolve. So I do think that it is helpful, especially if the losing side wants to file a public lawsuit in litigation in a de novo fashion. You see what their complaint is about and how it deviates or doesn't deviate. Because sometimes what we do see something where, from a litigation strategy, there are certain disputes in arbitration that are not subject to arbitration. So the caveat might be, well, there might be legal disputes that are arbitrated, but I haven't put all my legal disputes on the table. Well, ultimately, if you lose and you file a lawsuit, well, hey, look, I now can, as a de novo, to appeal my de novo rights, I can demand the kitchen sink in good faith. So you also need to understand, and I guess it gets lost, is Sometimes arbitration disputes are not all of the disputes at the disposal of the property owner.
Understood.
Thanks, Jeff. I appreciate that.
So I think three more things that I'd like to hit upon if we have time.
Yeah, we have time.
So binding arbitration.
Yes, that was one point I'd like to touch upon.
You go through the arbitration process, it's binding as opposed to non-binding. What does that look like? And I know Marty in his back pocket has a Reddit rapid fire that we'd like to do with you, Jeff.
Oh,
and
boy.
Then lastly, we're going to tease Jeff's next episode.
Yeah.
So I think let's start with binding briefly, just kind of go over that flow. You've gone through the arbitration process. It's binding. Homeowner wins. What does that look like?
So, and also, I think it is important to say very briefly that certain documentation, your condo docs, your HOA governing documents, sometimes might have arbitration provisions. Those provisions are pretty important to recognize, but it is important to understand that there can be some interplay between what is in your governing documents versus what are your statutory rights. There's various law on that, and we might have a podcast on that issue in and of itself. That's a whole podcast on, hey, if I have an arbitration provision in my governing documents, am I only subject to arbitration? And the quick answer is not necessarily, or as Luke Corso would say on college game day, not so fast. So ultimately, though, to answer your question, in terms of mandatory or binding arbitrations, and usually that comes in the form of a recall or election disputes. What happens next? Well, most likely what happens next, if it is binding, then it becomes a dispute of enforcement of that order. And then the second part is the prevailing party fees. Because in an election process or a recall process through binding arbitration, the winning side is entitled to their prevailing party fees, and those are the legal winning reasonable fees. And that's where the winning side can put forth various arguments to say, hey, look, we spent this much time and effort, and based on our experience, we believe that the fees incurred to get to this point were reasonable. And then the other side is going to try to do everything in their power to bring that down. And then ultimately, the arbitrator makes a final order of not only the substance of the decision, but if there are fees awarded as well. And in certain scenarios, they actually are not. For example, if a person who was actually recalled on the board tries to submit a petition saying, hey, I should not have been recalled, and the arbitrator finds that that petition was in good faith at the very least, well, then the winning side might not necessarily be subject to their prevailing party fees. So there are some legal nuances. It's not just whoever wins in a binding arbitration is allowed, but that's where you might need a lawyer to kind of walk you through some of those pointers.
Understood.
So binding arbitration means that it's a done deal. Like the court sees, it doesn't see court, but this is a legal you won, much like the winning of a lawsuit.
Well, it sounds, binding arbitration becomes a final event. If that's a way to put a bow on that, right? There's finality to the culmination, whereas non-binding, who knows? It could take off into another forum.
It's very simple. If it's binding arbitration and there's a final order, the tribe has spoken.
Okay.
Well said.
And then you can't, there's no way to, the party that loses can't take that there's no appeal to that. It's done.
Jeff, how does that work in Florida? What are the appeal rights in Florida for binding arbitration?
In binding arbitration, as far as I know, there are very limited rights to appeal.
That's
it really gives
California.
It gives a lot of deference to the DBPR in making those decisions on certain binding disputes. And by the way, I should say sometimes an arbitrator can actually order the parties to a mediation. So ultimately that there are some nuances of, hey, you might not be able, if you want arbitration, well, an arbitrator might say, hey, look, you guys should talk it out first before I make a pretty important decision.
Interesting.
So let me see if my non-lawyer head can project this back to you, Jeff, and you tell me where I'm off. Okay, here we go. So lawsuit, I have a problem. It doesn't matter what the dispute is at this point.
Okay.
And I hire this law firm and I say, okay, here's my dispute. And Jeff goes over the dispute he says, okay, based on the dispute, here's the options we have. We've got, depending on what the CC&Rs say, that could determine whether you're going to arbitration, mediation, or you can file a lawsuit. But it doesn't, if it doesn't specify, you could, Jeff will have, he'll try to say, well, we might try mediation because of X, Y, and Z. That would be an option. The other option is that in the law itself might dictate, depending on the dispute, where you have to go first. Whether it's some sort where you're going mediation, arbitration, litigation, or you get to choose, right? And then Jeff would lay out the lay of the land based on that.
Plan.
Okay. So far, so good? So far, so good?
Yes, but however, to make a very important point, there's a very important legal distinction when it comes to living in a condo versus an HOA, that if you live in a condominium specifically, the law changed 2 years ago where the statute says that if you have a certain legal dispute, you actually would have the right to choose between arbitration and mediation. However, certain disputes, if you live in an HOA, you don't get that choice. So there is some nuance into how you choose, and there are a lot of practicalities. There are certain thoughts about the actual dispute, the strategy of how you want to approach it. So, but I will tell you that usually, if you live in a condo, you do have a little bit more. You do have more choice than maybe living in an HOA.
Oh, interesting. Okay.
That's good to know.
Okay, so mediation, you bring forth 5 different potential parties that could be mediators, okay? The other side has to pick one of them, but they could pick up to 4 or 5 or whatever, and then it's the other side's choice to pick whoever they want at that particular time. Mediation is non-binding, meaning that both sides can say, we don't come to a resolution, kick rocks, and this is all a waste of time. It can potentially go that way. If they agree, everyone's happy, everyone signs away, good to go. In arbitration, there's binding arbitration, which means that it functions much like the courts or a judge on that side, where the judge or the arbitrator hears it out, determines what the fate is, and that's a done deal. However, non-binding arbitration, it's non-binding, at which point the other side can say, well, we're going to go to file a lawsuit or do whatever they want with it. They don't have to agree to it.
I think that's a nice recap.
So far, so good?
I feel like you are a good Jedi Knight for sure.
Okay. So one question then. What is the major difference then between mediation and non-binding arbitration? Because at its core, it seems like they're pretty similar. You've got a third party, right? And if it's non-binding, then both parties can potentially walk away and say nothing. So I don't understand the distinction between non-binding arbitration and mediation. If you want to give me the 30-second...
I say 30-second overview, then we jump into the Reddit.
Yeah, I know. That's it. Because this is my boat. This is my boat.
Yeah, I'll do less than 10 seconds on that question. Okay. Mediation, you're trying to resolve. It's as simple as that. You are not trying to escalate. You're not trying to go through a long process in trying to determine a winner and loser. Mediation is literally attempting to resolve your differences right out of the gate, without attempts to decide, who's right and who's wrong. And so even though the mechanisms might be the after the fact might be the similar in that respect, at the end of the day, there are some nuances. And I think the emotional nuance is really important to grasp, which is you're trying to resolve it so everybody can move in peace in the same community.
Okay, so mediation is we're trying to come to a negotiation, whereas arbitration is I will hear the arguments and I will say what I believe to be the correct outcome. Is that a better like some? Okay, good. My brain got it. All right, Jeff, I've got a fun. We've done this with a few people, and we do this with Luke every once in a while.
I like these. Jeff. These are fun. It's like a bar exam on a podcast.
Okay, so there is a subreddit that has it's tasty. It's people that don't like their HOAs. Okay, and all they do is complain about their HOAs, and they put forth some sort of a problem or just want to rant about it. So I usually briefly read what the post is, and I'm going to let you guys just tell me what your thoughts are on it as an HOA attorney.
This is Jeff's show. This is Under Florida.
Okay.
I will sit back, grab some popcorn, and watch Jeff do his magic on it.
Okay, here we go. You ready, Jeff?
Broccoli.
All
Sure,
right.
go for it.
Hello, all. My husband and I moved into our first home with the help of a VA loan. We saw a paid assessment letter signed by the HOA saying the house was free and clear of all violations. This apparently was not the case as of 3 months after owning the home. We received a notice of violation that our, quote, addition to our driveway was not approved. This came to a shock to us as we never did any construction on the driveway, as we had only owned the house for 3 months and had done zero additions to anything. Turns out the guy we bought the house from had been fighting the HOA for, in all caps, years regarding this addition of walkways to the driveway. The HOA signed paperwork that said the house was not violating any of its guidelines. Our HOA is headed by some corporation, and the point of contact for them was shocked that the house was ever allowed to be sold and had put a freeze on any fines. What do I do?
I love the all caps, by the way.
Yeah.
There's always an all caps.
Yeah, no, I think the first thing they've got to do is figure out what actually happened in the past. I would immediately use one of their statutory rights as the new homeowners or relatively new homeowners to get access to the official records, figure out what the disputes were and why, and then ultimately why it was never mentioned either in the association's estoppel letter during the purchase process or why it wasn't mentioned by the seller during the due diligence period. So there might be some interaction there, but in terms of escalating against an association to say, hey, look, I never knew about this. You told me or through the letter and through our due diligence that there were no issues. And I relied on that to ultimately close on the property because maybe I wouldn't have closed on the property if I knew about these pending issues. So there might be some legal concerns for the HOA, but I would, if I were these people, I feel bad for them, but I would probably want to see what the records say and how contentious it was prior to the purchase. And
So in other
perhaps
words,
even the seller might have exposure because the seller might have been wanting to get out of there because of this, and maybe the seller didn't disclose it as he or she or it should have.
so non-disclosure issue potentially of the seller of the home, but then the HOA signed it away saying that there is no problem too. So it sounds like the potential or the
Multiple targets.
buyer has a lot of
Also depends if the buyers were interviewed, because in a lot of HOAs they have to go through a pre-approval process, and usually during an interview that's something that should have come up perhaps.
Oh, interesting. We don't have that in California that I'm aware of. Interview process.
Yeah. Can you imagine? That's interesting.
I can imagine.
Oh yeah.
Well, Jeff,
That was
been
fun.
excellent. It's always a pleasure to have you on the show. And I think this is one of those foundational podcasts where someone can come to it and learn so much and become that much more empowered when dealing with a bad HOA. So I want to thank you very much for being on the show. And also, if we want to tease the next episode.
Yeah. So the next time we're going to be seeing Jeff, we're going to be going over the 2025 laws. The one of the best, most viewed videos that we have was Jeff reviewing all the changes that happened in 2024 that received a ton of comments and views. And so we're going to replicate that. We're going to see all the 2025 laws that potentially changed, and Jeff will be our guide on that one as well.
Wonderful. Well, Jeff, thank you so much.
Thank you very much for having us. At the end of the day, I just hope whoever watched this learns one thing. Because if you learn one thing today, you're more informed. And from our perspective in representing property owners throughout the states of Florida and California, but at least speaking only for Florida, I just want you to know what your rights are, because that's half the battle.
Well, Jeff, target achieved, because right here, I definitely learned something as the non-lawyer and homeowner in this room as well. So
yeah, that was
job done.
That was packed full of information. So thank you, Jeff, and until next time.
Sounds good. Thank you again.
Thank you. Take care, and thank you guys for watching.
And leave the comments. Leave the comments. We do
we
read
love
them.
comments.
We do read them, and
comments.
if there's some that you want Jeff to respond to, we'll put them in front of him as well.
Well said, Marty. All right, guys, take care.